Hello, everybody, and welcome to History/Law Bite number 151, dated January 5th, 2020. I'm Walter, your mobile historian and blue-collar scholar. This History/Law Bite is entitled Shelley versus Kraemer, 334 U.S. 1, 1948. Shelley versus Kraemer was a landmark U.S. Supreme Court decision which addressed the subject of the constitutionality of racially restrictive housing covenants. If you're not familiar what they were, all right, and still are, all right, because they still do technically exist, although you have to be kind of on the hush about them. Racially restrictive housing covenants are essentially agreements, usually made by homeowners in a neighborhood, where they agree that they typically will not rent or sell their property to members of certain racial groups. All right? In this case, the discrimination was directed against African Americans as well as Asian Americans. But of course, such covenants could be directed theoretically at any racial group. All right? It could be directed against whites. Okay? It could be directed against Latinos. It doesn't make a difference. The point is that the covenants specifically forbade the homeowner from renting or selling their property to members of particular races. All right? And this case came down in 1948. So we're just a few years out from the end of World War II. And for the past 15 years prior, all right, there had been many challenges to the separate but equal, okay, doctrine set forth from the Plessy versus Ferguson case, all right. African American plaintiffs had been challenging segregation in numerous areas of public life in the United States to this point. And some areas they were successful, in other areas they were not, okay? But it became clear by the late 1940s and early 1950s that segregation was not going to be simply tolerated anymore by African Americans and other racial groups who felt the stinging and very evil effects of being excluded and treated like second and third class citizens. All right? So, what exactly happened in Shelley versus Kraemer? Well, an African American family with the last name of Shelley, all right, moved into a home in St. Louis, Missouri in 1945. Unbeknownst to the Shelleys, the home was under a racially restrictive housing covenant. The covenant specifically forbade the home from being sold to a member of the Negro or Mongolian race, translated into modern terminology, no blacks or Asians, okay? And a man named Kraemer, who lived 10 blocks away from the Shelleys, not even within sight of them, decided to enforce this covenant, as he apparently was within the range of homes in the neighborhood that were protected by this covenant, and typically anybody who was under the covenant could sue in court for its enforcement. Okay, so the Shelleys theoretically, their ownership of the property was not exactly so sure, all right, with this pending litigation, all right? So Kraemer files suit in the Missouri courts, all right? The Shelleys win initially, all right? Their victory, however, is overturned by the Supreme Court of Missouri, which upheld the validity of the racially restrictive housing covenant. So, on appeal to the Supreme Court of the United States from the Supreme Court of Missouri, the justices were faced with two specific questions. First and foremost, were racially restrictive housing covenants valid under the 14th Amendment to the United States Constitution. And, more specifically, if they are, can they be enforced by a state court? In a unanimous decision delivered by Chief Justice Fred Vinson, the court ruled, quite simply, that while racially restrictive housing covenants of and in themselves were not unconstitutional, as they could be made by in between private parties and then enforced by the parties themselves, so to speak, they would be unconstitutional if a state court was to enforce them, as the state would then be giving legal sanction to racial discrimination between citizens, something that is clearly a violation of the Equal Protection Clause of that amendment. All right? The Supreme Court rejected arguments that it was okay under the Equal Protection Clause because blacks could do the same and exclude whites. All right? The justices, through Vinson specifically, rejected such bogus assertions as the fulfillment of equal protection of the laws cannot happen with discriminatory practices per se being allowed, whether or not blacks are allowed to do it to whites and whites are allowed to do it to blacks in this circumstance. Equal protection of the laws cannot prevail if discrimination is permitted and enforced by the courts of the state. All right? So, once again, the holding of the court in Shelley versus Kraemer was that while racially restrictive housing covenants per se did not violate the Constitution, okay, because it's just essentially an agreement between two or more persons, all right? And they can enforce that on their own. An individual can still refuse to sell their house, according to this decision, to a member of a particular race that they don't want to sell it to, okay? Or rent it to, or not rent it to a member of a particular race they don't want to rent it to. That type of agreement could be made and mutually enforced between individual parties. However, it was unconstitutional to get the state courts to enforce these racially restrictive covenants, all right? That is tantamount to state-enforced racial discrimination, a clear violation of the Equal Protection Clause of the 14th Amendment. Getting the state to enforce racial discrimination is a violation of the 14th Amendment's Equal Protection Clause, an obligation to the states to treat all persons similarly situated equally, unless you have a very, very, very good or substantial reason for not doing so. All right? And thus, the judgment of the Supreme Court of Missouri was overturned. All right? And the Shelleys prevailed. The significance of this case, quite simply, is that it ended effectively all legal support for the enforcement, all right, of racially restrictive housing covenants. So those who chose, homeowners in neighborhoods who chose to still make these covenants, okay, could no longer have the courts enforce them. So essentially, if they wanted to keep their neighborhood all white or all black or whatever, they had to do that on their own. They could no longer get state courts involved to enforce these contracts, as that would be a clear violation of the 14th Amendment, getting the state courts involved, okay? So they could make the contracts all they want, but they couldn't get the state courts to enforce them. That would be unconstitutional, all right? This was a very significant decision, all right, which certainly pushed the country in the direction of fair housing, all right, regardless of an individual's race. And certainly, African Americans, after this decision, in all likelihood found it much easier to obtain homes in many locales than they had before, as these racially restrictive covenants could no longer be enforced in courts of law in the states. Okay? Interestingly enough, as in Brown versus Board of Education, a few years later, the U.S. Justice Department filed a brief in support of the Shelleys in this case, asking the justices to overturn the Supreme Court of Missouri and rule in favor of the African American plaintiffs here. All right, Justice Department in this period was typically very supportive of African American plaintiffs seeking a redress for civil rights violations. Okay, this case was also decided with companion cases Hurd versus Hodge and Usiolo versus Hodge. Okay, one of which of these cases came from, these were both actually from the District of Columbia. All right. And of course, both coming from the District of Columbia, it is not bound, the district is not bound by the 14th Amendment. Okay. So the justices interpreted the Civil Rights Act of 1866 to strike down these similar racially restrictive covenants in use in the District of Columbia. All right, remember, the 14th Amendment is only applicable to the states, not federal enclaves such as Washington, D.C. All right, so, or the federal government in general. All right, when it comes to due process, the court has used the Fifth Amendment's due process clause to apply to the federal government. One last interesting thing about Shelley versus Kraemer that I think you'll probably find very, very humorous is that three members of the court, Justices Robert Jackson, Stanley Reed, and Wiley Rutledge, all recused themselves from this case because, guess why? Yes, you got it. All three members of the court lived in dwellings with racially restrictive housing covenants. At least they had the decency to take themselves off this case with a clear conflict of interest. So that is Shelley versus Kraemer, folks. If you have any questions or controversies, leave them down below and I'll be happy to answer them. All right. I think it's a very interesting case. And of course, certain definitely other laws exist now that certainly would make discriminating against individuals in housing merely because of their race, gender, very much against the law, okay, in spite of these covenants, all right? I'm not a real estate attorney, so I'm not going to even try to get into the heavy logistics of that one. But overall, since this decision, you've had a great deal of laws enacted at both state and federal level to prohibit various forms of discrimination in housing. All right? So again, any questions, controversies, leave them down below. I'll be happy to answer them. If you have not subscribed to my channel, just hit that little red subscribe button and the little bell, and we're in business. Take care, stay safe out there, and I'll talk to you at the next bite. Peace.